Orlando, Florida attorney L. Reed Bloodworth is managing partner of Bloodworth Law PLLC with offices in Orlando and Winter Haven. Bloodworth Law, a 2020 and 2021 U.S. News & World Report Best Law Firm. Reed is a 2021 U.S. News & World Report Best Lawyer in Trusts and Estates Litigation and handles estate planning, including the establishment of trusts for clients in most Florida cities, counties, and courts. Should you establish a trust? Trusts are a great tool, for example, if you have a child or grandchild that you want to leave a gift to, but do not want to give it to them all at once. A trust allows the grantor to make the gifts in increments. Trusts can be simple or complicated. It all depends on what your goals are. Revocable trusts are flexible and tailored to each individual's needs and goals. If a beneficiary has an addiction problem, the trust can address the distributions and place restrictions on them. While a revocable trust is more expensive to prepare than a basic last will and testament, the process of probate is usually more expensive than drafting a trust. If the trust was fully and properly funded, the expense of probate can be avoided, thereby leaving more assets for your loved ones. If the trust is not funded, underfunded, or funded incorrectly, the trust will not avoid probate. A trust also protects your privacy. A last will and testament needs to be filed with the clerk of the court and becomes public record, while a trust does not. To make sure the trust is fully funded, the grantor must fund the trust by updating beneficiaries and retitling assets such as bank accounts or real estate. Even if the trust is fully and properly funded, sometimes a probate proceeding is initiated to run the creditor period. Revocable trusts do not protect from creditors. As long as you are living, you have the ability to change the terms of the trust. You can add to or delete from or terminate the trust. But essentially, you still personally own the assets of the trust. A trust does not go through probate, but a notice of trust must be filed, and if there is a creditor, creditors typically have up to 2 years to file a claim. If a probate proceeding is started, the creditor period is much shorter, usually 3 to 4 months. Establishing a trust is a personal financial decision that may not be right for everyone. Talk with Reed about how the Bloodworth Law Estate Planning Team can help you, your family, or your business.